Madam, I rise to move that the bill further to amend the Companies Act 2013 be taken into consideration. Madam, in fact, the government constituted a committee in July 2018 under the chairmanship of the Secretary of the MCA with a view to review the existing framework of the Companies Act 2013 and make the certain recommendation with respect to the offences and with respect to the related matters. The committee held number of meetings, and for recategorization of the offences, the committee made recategorization of the offences. Those were of the compoundable nature, and those offences were normally, before that, those offences were required to be adjudicated by the special courts as well as by the NCLT. Therefore, those offences were taken out from the special courts as well as from the special courts and from the NCLT. Therefore, the committee gave its recommendation on 27th of August 2018, and with respect to the severity of the offences, certain offences of a serious nature under section 447, those offences was retained as such. The offences which were of compoundable nature, those offences were taken out, and it has been provided to the in-house mechanism, and that mechanism has been to be enhanced and to be provided in the ministry itself. Now, it will serve the twin purpose. One is because the certain lapses were there. In case of lapses of technical nature and procedural nature, those offences were required to go before the special courts. Those offences were required to go before the NCLT. Therefore, that offences of the certain lapse of the technical and procedural nature, those were taken out, and those were provided in the in-house mechanism. So it will basically, with a view to provide ease of doing business and better corporate compliance. And apart from this will also reduce the prosecution before the special courts, and also provide this expedient disposal and take up the serious matter by the special court and NCLT. Therefore, these recommendations were made, and the major recommendation, I would like to refer only the major recommendation regarding some of the 16 offences were recategorized, and those were taken as a civil defaults, and those were taken out from the special courts. And with respect to the transfer of the routine matter, normally every matter required to go before the NCLT, small matters, so even for the change of year, financial year and like that, so those matters have been taken out of the NCLT, and in-house procedure have been provided for that. And the small matter like application for change of financial year and conversion from public to private companies, so these matters are not required to be dealt with by the NCLT with that view. So these matters were also be taken out. And apart from this, two provisions, section 10A and 12 were also introduced, and section 10A provides that in case the non-maintenance of registered office, then the provision have been provided that that company can be struck off. And apart from this, in case of non-reporting of the commencement of the business, they have to require to declare that, and the share is required to be paid up by all the these members. And in case they fail to do it, then the provision for a striking off is also provided. So these are, apart from this, some stringent provision have also been provided for creation and modification of the charges. And in case of breach of directorship, because under section 165 the number of directors have been provided, and in case of breach, then under section 164(1), certain provisions are there that the company can also be struck off. And apart from this, ma'am, to enlarge the jurisdiction of the regional director, because for the small matters we were required to, the company is required to go before the NCLT. So the jurisdiction of this regional director was enhanced from 20 lakhs to 50 lakhs. Therefore, the small matters are not required to go there, and the in-house procedure, those matters can be dealt with by them. So at the time, the parliament, these were the amendments which were of the urgent nature, and parliament was not in session. Therefore, the ordinance was there. Now with this, sir, Madam, I request the honorable members to kindly consider and pass this bill.